Hey there, everybody. Welcome to another episode of the Justice Revolution. I'm your host, James the Patriot. Today is, oh my heck, what is today?
The 10th.
There we go. Thank you.
Friday, the 10th.
Friday, March the 10th, in the year of our Lord, 2023. I have my co-hosts with us, Erica and Justice. Say hello, ladies.
Good afternoon, everyone.
Yeah, it's good morning, actually. Well, I guess it depends on where you are. For Erica, it's afternoon. For Justice and I, it's morning. We're doing this. We're doing our show a little early than we normally do. So, but anyway, what's new, guys? I mean, it's been a week, but what's new?
Snow.
But yes. What's new with you, Erica?
Wind and rain. It's freezing cold here.
The weather.
Just enough to tease us, like, have a couple nice days where I could lay out and come back and get the all bundled up again.
Mm-hmm. I know. I'm about. No, I'm not about. I am ready. I'm ready for spring. Let's bring on the warmer weather. It's time to get outside. My kids are going nuts. They want to be able to go outside and play, and it's getting tough.
Yeah, I'm like
the garden's ready, and
no kidding. Poor Justice is buried under how many feet of snow now? 20?
Like 7. We're at 7,000 feet, so we're like ski country, and it's just the resorts are happy, but
I know.
Mm-mm.
Yeah,
and
they said
it's dumping right now.
Yeah, they said that the ski resorts here in Utah are extending ski season by an additional 2 weeks because of so much snow.
And everybody's roofs are leaking, including mine. Ice dams and a lot of insurance claims happening right now.
Oh, it's terrible. I'm more concerned about when it melts. That's my concern.
Yeah, we have some rough flooding down there in the valley, don't we?
Yeah, well, the last time we had as much snow as we've had this last winter was 1983. So it was 1982 going into 83. And I don't know if you were here, Justice. I was just a baby.
No.
I was 2 years old. But there was a river in down the street in the streets of Salt Lake. So
it might happen again.
It might. So anyway, boy, so what's new with you, Erica? Anything besides the wind, the rain, the snow, or
well, we're still keeping an eye on this whole hazmat situation, transporting all the hazardous waste to 20 minutes away from our new property. So our wiener of a governor, he postponed it for one day, and then it's back on with the truck deliveries. So I just can't wrap my head around what is going on right now with with all of these train derailments. So yeah, there's a bunch.
Yeah.
So I was listening to someone talking about taking legal action against their governor, and it was in Michigan and somewhere else. And it stops the influx of this toxic stuff coming in. So let's talk about that after the show. That might be a good subject for you and for other people.
Yeah.
You contaminate. Now they're spreading the contamination all over the country, right? It makes no sense.
Yeah.
And honestly, we don't really know what's true. Let's just be honest.
Yeah.
Like, there's games being played everywhere. That's why I'm not letting myself get too fired up about anything, because who knows what's really true? Is it just all made up? They trying to get us all riled up and show some involvement, signs of life out here. I don't know. Is it stuff that's able to be filtered easily if it is hazmat? Was there even really a big explosion? I don't know. They can make anything look like anything they want to these days.
Yeah.
One of my precursors to suspicion was President Trump actually going to Palestine, because if it was that toxic, he wouldn't have gone. That's just my opinion. He plays too vital of a role to. It's almost like when he, did the the alternative stuff for the to show people it's not what they're saying it is, right? I don't know. That was just a thought. But anyway.
Yeah, you don't know what to know anymore. You don't know what to believe anymore.
We don't know what we don't know.
Exactly.
So, which is a lot. The more I know, the less I know.
Which is warfare in itself.
Yeah, I know. So No, I keep seeing more and more reports, more train derailments. There's one in Alabama. There's another one in West Virginia. There's one in Texas. I mean, I never heard of, unless it was a serious train derailment, you never heard of these things. And that now all of a sudden you've got serious train derailments one after another. So,
and warehouses catching on fire.
And warehouses. And yeah, just be diligent, guys. That's all we can say. So, with that, I do want to touch on something that that is very difficult to talk about. I'm sure some of you or many of you have seen. We had an officer involved shooting here in Utah. It was towards the I believe it's toward the beginning of this month in March. Farmington Police Department, which is not too far from where I live. It's a little further from where Justice is, but they, for those of you who may not be up to speed, there was a young man who was driving around with one of those license plates where it is commonly associated with the sovereign citizen movement. So it said, I don't remember, it was like private vehicle not for hire, something like that. I don't know. So an officer initiated a traffic stop, pulled him over, and this young man, he was actually very bright when it came to dealing with them. He knew how to deal with police, and the first thing he says is, "I don't answer questions." We've talked about that before, I think.
Wasn't he studying law and helping his mother with something previously also?
Exactly. Yeah. So he says, "I'm sorry, I don't answer questions." Now, where it took a turn for the worse was, you have to realize when you're pulled over by one of these guys, there's no amount of talking that you can say that's going to get you out of that situation that's going to be good. Let me put it to you that way. If you're pulled over by them, you absolutely do not need to say anything incriminating. So you can absolutely say, and this is what I teach my daughter, and this is what I would do if I was pulled over, say, "Hey, can anything, can anything I say be used against me?" He's going to have to answer yes. Well, okay, then I choose to remain silent. That's my Fifth Amendment protected right. I choose to remain silent. You have a right against self-incrimination. Mm-hmm. These guys cannot force you to incriminate yourself. So here in Utah, every state is different around this whole identify thing. So where this interaction took a turn for the worse, in my opinion, was the officer said he pulled him over because he didn't have his car registered. Now that's a discussion for another day, whether that needs to happen or not. You guys know where I stand on that. Pick your freaking battles. Let's not sweat the small stuff. I'm not going to deal with a road pirate. I'm not going to win against a road pirate, even though I have a right, a God-given right, to go where I please, when I please, in my private property. The Supreme Court has said as much. So, in case if any of you are wondering, the landmark case was Murdoch versus Pennsylvania. A state cannot convert a right into a privilege and charge a fee for it. That's not how it works, but they do it anyway. So he was pulled over for that. The officer said, "I need your driver's license." And he said, "No, I don't have to identify." He's, I'm not giving you any information. I want to tell you right now, he's not wrong. However, do you think he's going to convince this officer, who's got a badge and a gun and a taser and some other stuff that could potentially kill you? Do you think you're going to convince him otherwise? When this officer has been trained that when he gives a command to somebody, they absolutely must follow it, and if they don't, he can effect an arrest. Right? Does that make sense to anybody?
Yes, totally.
Okay. So he gets into a little bit back and forth with this officer. Eventually, he gives the officer his passport that has his name on there. And I don't remember exactly. I'm paraphrasing here. At some point, the officer, as soon as he walks up to the car and he says, "I don't answer questions," he's, "Oh, I'm going to need a bunch of people here." So he calls in a bunch of backup. 4 or 5 or more officers show up. Then the next interaction you see is they give him a command to get out of the vehicle, and he says no. They do it again, and he says no. Then they physically open the door, and this is where all hell breaks loose. I don't know. The video is not very clear. And let me put it this way. The video does not show what they purport was there. So what happens is they open the door, there's a little bit of a struggle, and then one of the officers yells, gun, 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 gun. And then all you hear is these guys just open up a barrage of fire. All 5 of these officers emptied their entire magazine into that car. That's 9 rounds. Or no, 12. No, yeah, 9 rounds. 9 rounds of their sidearms into that car. Then the next part of this video, and by the way, this is body camera footage. It's available on YouTube. I believe it was posted by the New York Times, or maybe it was, no, Salt Lake Tribune. It's posted by the Salt Lake Tribune.
Do you know if he was running the camera on his phone?
He was, yep. In one part of the video, you see him holding his phone like this, or I should say it's more like this, where he has the camera side of it aimed at the officer talking to him in the window. Now, the reports that are coming out, and they're still unverified, that said he had a firearm that was holstered on his right hip. Okay. Erica, what's the Second Amendment? You know what the Second Amendment says?
The right to bear arms uninfringed.
So let's make sure we state this for everybody so it's very clear. The right to keep and bear arms shall not be infringed. Period. Okay? No laws can be passed that would deter your right to keep and bear arms. None. Right? Just because this young man may or may not, I don't know, I haven't seen it, and I don't want to speculate. I'm not adding to speculation. I'm just telling you, I reviewed the video footage. I didn't see anything. So this is what I'm saying. Just because he had one or didn't have one did not give those officers a right to just open season fire. It didn't. Now, that being said, I don't know if, I mean, the evidence that I've seen leads me to believe that he didn't go for his weapon. I don't know. There is a still frame. Somebody captured a still frame of the incident right before. It's like a second before they open fire. And you can see both of his hands are free.
So this is a smart child from what I've read about him.
He was extremely intelligent. Yes.
Nobody in their right mind is going to go for their weapon, especially studying common law or lawful actions with 5 police surrounding their car and holding a camera at the same time. There's so many holes in it. We just pray.
There's so many inconsistencies. So let me tell you the biggest inconsistency for me. Okay. After they open fire, then you hear somebody says, cease fire, cease fire. Then these, and I'm trying not to get, I don't want to throw emotional stuff in here. So I'm just going to give you the story as it is. Then you hear one of the officers say, show me your effing hands. Show me your hands. Then another officer approaches and somebody says, Sarge, stay back, stay back. Then they go up, and the next thing they do is they drag him out of the car saying, show me your hands, throw him on his chest, and handcuff him.
Okay? And shoot him after he was handcuffed?
No. There was no more shots that were fired after they dragged him out of his car.
Oh, however, oh my God, really?
However, and this is from the medical examiners, the ME report said there were 2 visible bullet wounds in his head. One entered right about here and came out his ear, and there was another one somewhere else. Not to mention everywhere else on his body. So that's the first problem. The second problem is, you guys know that my day job is I work with law enforcement. So I'm pretty familiar with, the protocols and what they do if there is a shooting, if somebody is threatening them with a weapon. So the standard operating procedure, the standard protocol, subdue the suspect, secure the weapon. Then make sure, because the idea is if you've got somebody who's threatening you with a gun, you're going to use deadly force to protect yourself. But in the effort that that individual is not killed, you need to secure the weapon in case they can go after it. There is no mention of the gun whatsoever the entire rest of the video.
And being outside the car, if that was the case truly, which makes no sense, all the police had to do was dive. It's crazy. It sound to me, I'm just going to be frank, it sounded like a hit job. That's what
the evidence is pointing that this is not going to turn out well for these officers.
Still doesn't bring back her son.
It doesn't bring him back. The moral of the story here, if there's a moral, is, guys, please, I beg you, I am pleading with you, do not have a roadside argument with these 8-year-olds with guns.
Right.
Please don't.
And this is the message, in my opinion.
Yeah.
And James has been saying it from the get-go. We have a mutual friend who got pulled over after going through the whole David, STRAIGHT. I don't even know if that's a bad word on YouTube, but going through that whole course, she wound up with a bench warrant after that. And she got pulled over and she was so confused and so scared. All she kept doing was screaming at the cop, I am a woman and I have my rights. And she had no idea what she was talking about. And she called me and I called James, and James talked the police down and explained the situation and so forth. But that it's not the place. James has been saying it for 2 years. That is not the place. It's the courtroom to have these kinds of, everything can be reversed. The cops can get penalized. It can all happen in the courtroom, but it's not going to happen on the side of the road with a trigger happy, angry cop, or even a non-trigger happy, angry cop. So
it's a very bad situation. And out of respect for the family, I'm not going to share more details. There are more details, but I'm not going to share what those are here. This is not the proper place to do so. Suffice it to say that this evidence needs to be turned over to a grand jury. They need to review this. Based on what I have seen, if the grand jury comes back with anything less than second-degree murder charges, then we are totally lost. We are totally lost.
What I saw, these guys cannot hide behind the costumes that they were wearing. They were armed men, and he was very clearly identifying himself as just traveling in the private. I'm a man here. He wasn't aggressive in any way whatsoever.
No.
They were the police officers were escalating it, but
he totally escalated it.
We have to stop looking at things from people who are claiming to behave the way that they're behaving because of whatever title they're playing, whatever title role they're playing at the time.
Yeah, and this is what I'm saying. If you find yourself in a situation where you're pulled over, I mean, who hasn't been pulled over? You get pulled over by one of the police. You do not have to incriminate yourself, but that doesn't mean that you create issues. So let me give you an example. Here in Utah, officers love to throw this failure to identify charge at people. Oh, you didn't identify to me when I asked you originally. Okay, that's a crime. No, it's not. Okay, you have a Fourth Amendment right to your privacy, and you cannot be unlawfully searched and/or seized just because somebody wants to know who you are. Now, with that being said, there is a law in the books. Whether it's lawful or not is a story for another day. It's a Utah Code, Title 77-7-15, and it states that if an officer has reasonable suspicion to believe that you have committed a crime, are committing a crime, or about to commit a crime, you are required to give him your name, address, and date of birth. There's nothing in that statute that says you're required to give him a driver's license. There's nothing in the statute that says you're required to give him any other identification information other than your name, address, and date of birth. Okay? So if you find yourself in that situation, give him your name, address, and your date of birth. You're not incriminating yourself by doing so.
And there's no reason not to, just because this movement of people are saying you don't have to. There's no reason not to.
Exactly.
Unless you're committing a crime and you're trying to hide.
Well, and here's the other thing too, is the Supreme Court has held that traffic infractions, so the officer states in the video he pulled him over for an unregistered vehicle. That's an infraction. Supreme Court has held an infraction is not a crime. So was he wrong that he didn't have to identify himself to the officer? No, he was not. Was he going to win that argument with that officer right then and there? No, he was not.
Read your audience. That's an important part of being able to stand up for your rights, is know when and where and how and what to say and when to say it.
Yeah, just realize the situation that we're in here, right? Am I going to win this argument right now? No, probably not.
Yeah.
So, do I want to play this game of Russian roulette with this guy who's itching for a fight and has got a deadly weapon on his hip? No, I do not.
In this era of lawlessness.
I mean, like I said, I mean, the woeful and inadequate training of our law enforcement officers needs to change, and it must change, but it won't until more people like us say, okay, you do what you're going to do. I'm going to bring you before a tribunal and have you answer to them.
We've seen some of the training information that they're sending out to the police officers regarding the sovereign, the people who are claiming to be sovereign. It's a shame that they're doing that. I don't know. I have lots of friends who are sovereigns, who have gone through the American State National process and stuff. And it's not characteristic. It doesn't describe, they're not horrible people at all. They're just trying to figure out the correct remedy for standing up for their rights.
Yeah.
Spiritual law. They just want to be a child of God and go about their business. Well, it's the same rap the conservatives are getting too, right?
Yeah.
Horrible insurrectionists. It's like, no, we love God. We want to be peaceful and live our lives with our children. That's it.
Yeah.
Well, and real quick, just to round out this conversation, we all need to realize we are all sovereign men and women. Our rights do not come from the government. Our rights do not come because we were born in the United States. Our rights come from our Creator. So you cannot, you can't have all of your rights converted into privileges, and then you have to be granted use to use those privileges. I've heard this before. They say driving is a privilege. It's not a right. Well, you might be correct. The term driving in and of itself is a commercial term. That is a privilege. But I have a right to travel in my personal conveyance. I can go wherever I want, how I please, as long as my actions don't harm anyone else, or I don't infringe on their rights, I have a right to go there. So,
but it's not a fight for the side of the road.
It's not a fight for the side of the road. So I don't know what's going to happen with this situation. It's heartbreaking. It really is hard. I mean, this was a bright young man. He was only 25 years old. And now
say prayers for the family, everybody.
And now he's gone. So, but I don't know. I don't want to say let's learn from it, but I mean, there's no other way to say that there's to learn from this. So, now that we got the depressing stuff out of the way, let's talk about what I wanted to talk about today. What do we do with these pesky debt collectors, and especially if they decide to sue you? So some of you guys have noticed in our Telegram chat group, I was chatting back and forth with this young woman who was running into some issues with this, and I called her and had a discussion, and she's been kind enough to come on the show. So I'm going to add Adrienne in and have her introduce herself, and then we're going to talk about her situation. Hey, Adrienne, how are you?
Good. How's it going?
Good. Welcome to the show.
Thank you. And thanks for putting me after the depressing stuff.
Yeah. That's sorry about that. I guess I should have prefaced that before. So I do have to chuckle a little bit because when we spoke on the phone, you're like, well, hey, if you don't mind, as long as I'm in my PJs, it's like, looks like you're doing just fine. So.
Oh no, I just covered the PJs. I'm still in the PJs.
Okay, good.
We're good. Got the coffee, got the PJs. We're good.
All right, you're ready. You're ready to go. Well, why don't you real quick give us a quick rundown of what's going on. You don't need to go into too many details, but what I want to get at is there are plenty of people that this is happening to, and I want to be able to help them as best we can. So tell us what's going on and where we are right now.
On the 12th of March, we got a knock on the door. It was a Sunday, and I got served with papers being sued. A law firm for a portfolio recovery services had served me. On Monday, I made the brilliant decision to try to set up a payment plan to avoid court. They said we're going to court anyway, and filed on the 16th. I believe it was that Thursday.
Mm-hmm.
And so I turned my answers in just this past Friday, just denying everything.
Okay.
I can't find this particular account even on my credit report.
Okay.
So I called and canceled the payment plan, which I have not made a payment yet. It was just an agreement to make.
It was just a tentative agreement. Do you have any idea what this could have been about? I mean, it's because it looks, and I'm going to open up here the actual complaint that you were served. And it says it was an account from Synchrony Bank.
The only information, because Synchrony holds accounts for basically if you open up store credit, it's Synchrony that is the bank.
Yeah.
I was verbally told what it was for, and I did have an account with that company, but I can't match up the information. Nothing that was in the, like, I don't know who it got assigned to. I don't know the amount. I don't know anything.
Okay.
So it is possible, but I have not been able to track it down with the information that I have.
Okay. Well, okay. So guys, what do? You've been served with this lawsuit. One of the things I wanted to touch on here in Utah, and it really irritates me, under the Utah Rules of Civil Procedure, you can serve a complaint on the defendant before it's actually filed with the court and before a summons is issued. I take big issue with that. But it also states in the rules that you must file the complaint within 10 days of the defendant being served. Otherwise, it's gone. So I guess they figure that does the same thing. But I know a lot of these shady liar firms will do this to scare people into doing exactly what Adrian tried to do and to get set up into a payment plan. So let's talk about
loan modification.
or another modification. Exactly. So let's talk about this. So you get this lawsuit. Let's just go over this real quick. So according to this lawsuit, the plaintiff is the Portfolio Recovery Associates LLC. I believe, actually, I do know that is a debt collection firm. That's all they do.
Yeah.
That's all they do. So they are claiming they have standing to bring this case. Remember that. They're claiming they have standing. All right. So here's the claims. Number one, the defendant resides in the county, which is Tooele, right here. They say the defendant opened an account with Synchrony Bank, ending in this account number. By the way, did you find this account number anywhere?
I found the last 4 of that account number, but that's it.
Oh yeah, so that's all they blank everything else out, but the last 4. Okay.
Yeah, I was able to match up the last 4, but I don't have a complete account number. So.
Okay. Their next claim is that an account was stated by and between Synchrony Bank and defendant, wherein it was ascertained at the closing of the account that said defendant owed this amount of money to Synchrony Bank. Synchrony Bank assigned the account to plaintiff. Okay, there's your problem right there. Whoops, I can't highlight it, but stop it. There we go. Sorry, stupid computers. So Synchrony Bank. I wonder if this will let me try it this way. Nope, it won't. Synchrony Bank assigned the account to plaintiff. The next thing, the amount charged off on the account was $1,200. There is now due and owing about $1,100. There is an account stated by operation of law wherein Synchrony Bank billed defendant for the credit balance, and defendant did not dispute the balance owing. The account has not been satisfied and is now due and owing from defendant. Okay, that's basically it. All right, let's break this down. Justice, Erica, what problems do you guys see with this?
Sir, well, the first thing off the top of my mind is I would ask, you know how I go, did you ever ask this recovery association if they had a contract with you?
That's a good point.
Actually, I haven't had any contact with Portfolio Recovery Services.
So you're not even in contract with them, which makes, in my opinion, under contract law, it's not valid because you're not contracted. You're only contracted with whatever the bank is. Yep. And I'm going to say that because last week I said it worked for me with American Express. They had people trying to get money from me because I chose not to be extorted during COVID. And I asked them if they had a contract with me to collect money. And they said, no. I said, the only contract I have is with American Express. Don't ever call me again. They never called me again. You know who my next phone call was from? American Express. So it's pretty powerful. Contract law is a thing. And if we don't know it, they're not going to tell us. So
okay, that's a good point.
That's the first thing right off the bat. So
that's right off the bat that jumps out to Justice. Erica, what about you? Anything jump out to you? Any problems with this?
Well, I'm just having more of a general response to the whole thing. The only reason that we use the court system, right, is because there's some sort of controversy that
there you go.
That needs to be resolved, right?
Okay.
So there's controversy somewhere. They're saying that there's a debt that is owed. They were hired to get the debt that was owed. It is our responsibility as men and women to live in honor. And so if there is a debt that is owed, it needs to be validated if you ask for it. The person with whom you entered into contract with needs to be the one bringing the standing for it. And you have the duty, if you are in debt to it, to provide remedy for it.
Exactly. We're honorable people. We don't enter into contracts and then go into breaking them.
Right.
But it doesn't mean that we're going to sit back and take it because some big bad bank sends you a statement says you owe us this money. You have every right under the law to verify. And they're required under the law to validate and verify. So that's a good point, Erica. There's a number of things that jump out to me. Jen G said this, and this is a great point. Charge off equals no debt. She's absolutely correct. If they charge it off, there's no debt. Because why do companies charge off balances?
To get
the insurance?
To get the insurance payment, yeah.
Insurance payment and or tax benefits, or both. Okay? So then Jen brings up the next thing. Jen, you're awesome, by the way. They have no standing. Okay? So here's the problem that I see with this. Okay? The named plaintiff is the party claiming to have standing, or the party with the real party in interest. So Portfolio Recovery Associates is claiming that Adrian has defrauded them in some shape or form or another. However, the own complaint itself states otherwise. Because the claims in the complaint say Synchrony this, Synchrony that, Synchrony this. If Synchrony wanted to try and sue Adrian, they could. So why isn't Synchrony bringing this action?
Exactly.
Right.
Okay.
That the original person you had the contract with.
That was my second observation. It was interesting. They're not even listed at all as per both of them.
Yeah. So here's the first thing, okay? Portfolio Recovery Associates has no standing. So that's the first one, right? That goes right to lack of subject matter jurisdiction. You must be a real party in interest. If you are not the real party in interest, you have no subject matter jurisdiction. There is no controversy before the court. Therefore, you have failed to state a claim upon which relief can be granted. The second issue is line number 6, where it states, there is an account stated by operation of law wherein Synchrony Bank billed the defendant for the credit balance and defendant did not dispute the balance owing. All right.
So
where's the proof of that?
Did you, yes, you said you didn't remember this at all. So where are they getting?
Well, this was actually an account that was opened pre-COVID. We were one of the victims of COVID employment. Well, my husband was.
Yeah, who wasn't?
I was a medical victim.
So it was an account that you do recognize?
Possibly, if it's the one that I tracked down. I did call when we were back to work, and they told me that it had already been charged off and there was nothing I could do. That was a couple of years ago, and this is the first I've heard of it since then.
Yeah. Yeah, sorry, go ahead, Justice.
I was just going to say, this is a big problem these big banks have done to people during COVID is extort them.
Mm-hmm. And this is very common. What happens is these rats, and I'm saying rats because they eat the crap of the earth. These debt collectors like Portfolio Recovery Associates, and the liar firms that represent them, and I have no problem showing you who that is. That's these morons right here. Sean Morrissey and Sean Big Fat Piggy Pig. Oh, sorry, Yumi Pig or Ummy Pig. I don't. It's a
now, James, come on.
That's a terrible name. How do you live with yourself, buddy? How'd you get through school?
Yeah. I knew a guy named Mark Wiener, so.
Oh, yeah. Okay. So Johnson Mark LLC. Adrian, you have this information here. I'm going to tell you some steps you're going to do right here pretty quick. Okay. So these two morons have put their name on here. They quote unquote signed it, but this is it. There's nothing else. So there's no proof that line 6 is accurate. There's no affidavit stating that what's here in this complaint is truthful. So is there really a controversy before the court is my question.
So there's no affidavit?
No, there's nothing. Adrian sent me everything, correct? You sent me everything that they sent you? That you were
Yep, the complaint and my reply, that was it.
Yep, no. So what do we do, guys? How do we handle this?
Countersue them.
Oh, yes. You can do one of two things. You can file a countersuit, which would be in the same court. I, for one, are like, I'd rather not adjudicate that in the same court, especially since I don't trust these state courts. You know, my trust in the federal courts is weaning. However, when you get to that level, there is an adult in the room, and as long as it's stated correctly, you're going to be just fine. So she filed an answer. Is it too late to file a motion to dismiss for failure to state a claim upon which relief can be granted?
No.
You can never be too late in submitting that one.
Especially
even if you go to jail for it, serve time. When you get out, then you can still ask them to dismiss it based on lack of subject matter jurisdiction.
Yes.
Correct. So what I'm going to recommend is that, and I'll help you with this, Adrian, is you'll write up a motion to dismiss. Okay. And you're going to bring up the facts that Portfolio Recovery Associates is not the real party in interest. They have stated no facts that you have. There is no facts within the complaint. And so here's how you attack a complaint with a motion to dismiss. You take what's there and go, well, the quote unquote facts you're purporting don't back up what you're saying, if that makes sense. So based on what they're saying here, the party with interest or that would have interest to bring suit is Synchrony Bank. Why didn't Synchrony Bank do this? Oh, I know, because right there on line number 5, they charged it off. Once they charged it off, they no longer have, they can't come after you.
That's very similar to the insurance payoffs with the mortgage.
Yeah. So Synchrony Bank chose, instead of choosing to file suit on their own, they chose to charge it off. So then what happens is these rats here, the Portfolio Recovery Associates, they go in and they buy this $1,200 debt for pennies on the dollar. They probably paid less than $200 for it. And now they're trying to extort the amount that's due in balance from Adrian and her husband.
They're like ambulance chasers.
Oh my gosh. Don't get me started. Okay. So how I would handle this is I would file a motion to dismiss for lack of subject matter jurisdiction, for failure to state a claim upon which relief can be granted, and point out all of the deficiencies based on what's here. Then I would submit that to the court with, what do I say we submit with everything, you guys?
An affidavit.
Affidavits. Can you believe it? Affidavits. Now, I have to clarify some things. There's some videos on our website that we're going to be updating soon. Affidavits on their own, if you just send someone an affidavit on their own, it does not require a response. However, when it's attached to a court pleading or a court document, it requires a response. That's where the power of affidavits. It also is you are testifying. So Adrian is coming forward as someone who has personal knowledge and can testify to the truthfulness of this, of the claims being made. And that's what that affidavit does. Now, the other side is going to file an objection to it. And then you're going to go back and say, nice try. You guys still don't have standing. Bring forward someone who has standing to corroborate your claims. So you've got, let me open it up again here. You've got Portfolio and Recovery Associates as the plaintiff. There's nobody signing this document on that's tied to them. You've got this attorney. He has no standing to bring these claims. He has no personal knowledge of these claims. Okay, that's how you attack this. Now, then, and Adrian, I don't know if you're taking notes. Before you do any of this stuff here, you're going to bar grieve the crap out of these two idiots right here, and you're also going to look up this Johnson Mark LLC attorney. Looks like it's jmlaw.com. You're going to find the named partners, and you're going to bar grieve the crap out of them too. So what's going to happen is they're going to get a bar grievance notification, and you're going to put in there, these two idiots brought a complaint against you. They have no personal knowledge of the situation. They have violated, these. Just pick something. It doesn't matter. And then the bar grievances, they're not going to do anything. They're not going to get reprimanded. The bar isn't going to come back and say, oh, you guys are in the doghouse. They're not going to do that. But the insurance company is going to go, why did somebody file 1, 2, and chances are there's at least 2, maybe 3 named partners. Why were 5 bar grievances filed against you guys in the matter of 2 days? That's a problem. And then these named partners are going to go, how much are you suing her for? $1,200 or $1,100, whatever it is. Looks like it's $1,100. You're suing her for $1,100, and we run the risk of losing our malpractice insurance. Drop this suit now. Now, if that doesn't do it, that coupled with your motions to dismiss will absolutely push this over the edge. Then what you're going to do, once that's done, then we start having some fun, and we're going to go after these portfolio idiots and this law firm for purporting fraud on the court, for racketeering and RICO claims. Then they're going to be in a world of hurt.
So, James?
Yes.
How do there has to be something written somewhere that unless it's just blatant crime, something somewhere that allows them to go ahead and purchase these things after they've been charged off. I mean, it's double dipping.
It is.
It's the same thing again with the mortgages and the insurance is double, triple, quadruple dipping. Where is the law that states that is illegal, or where is the loophole for them?
So it's not illegal to buy charged off debt. That's not illegal itself.
It should be.
It should be, but it's not. There are a number of laws surrounding the collection of those debts, like the Fair Debt Collection Practices Act. The situation with the Fair Debt Collection Practices Act is it states that, so like Portfolio Recovery Associates, if they had sent statements to Adrian saying they're trying to collect this debt on behalf of Synchrony Bank, that's above water. That's totally fine. But they can't sue her directly. Only Synchrony Bank does. That is the party with interest here, allegedly, right? Mm-hmm. But according to this document, they charged it off. So if they've charged it off, then they have no interest. So here's what would happen. If Adrian tried to call Synchrony Bank and say, oh, I'm so sorry, I was out of work due to COVID. I now have the money. I want to pay you guys back. They'd be like, well, we can't take your money. We charge it off. Oh, okay. So the contract is satisfied then.
That's the important step in coming forth with remedy, I believe, on the part to be able to come in honor and to go before the court with clean hands in this situation is to show that you have made an attempt at a remedy. Yeah.
Yep. And that's the truth.
And always to claim that it's not your intent not to pay anything you lawfully owe.
Yeah. I mean, so I got a letter from, I don't remember who it was from. I got a debt collection letter, and I wrote him back and I said, hey, I just want to be very clear. It's not my intent. It is not now, nor has it ever been my intent to avoid paying a debt which I may lawfully owe. But in order to ascertain if this is something that I owe, I need you to do this. The law states they must validate the debt. Well, what happens when you request a validation of a debt? Have you guys done that before, Erica?
Yeah, I have.
So when you request someone, and Adrian, you're shaking your head no.
I haven't requested it. No, I've always been the one to call and be like, "Hey, I can't pay. Here's why," and then call back when I'm like, "Hey, I can pay."
Yeah.
But then it's too late. So
if there's something that I can teach everyone, and this is what I want to teach you guys, is not just you, Adrian, but anyone watching or listening, do everything in writing. Avoid the phone as much as you can. Do everything in writing. Okay. So here's what happened in my case. And Erica, I was going to have you say, because you've requested a validation. What did they send you?
Well, I had two different responses. I sent it to two different banks regarding mortgage information. One of the banks sent me a response that said, "Yeah, your request is it's too much, and it's really specific on what it is that you're asking for exactly. We're denying your request." It was a little draconian, my list of validation request information. However, I felt it necessary to gather the full amount of information that I was after. And then the other bank sent me a response of information this thick that I'm still going through, trying to figure out if they actually answered the questions that I had. So far, no. So far, no. It's either they tell you nothing, or they overwhelm you with tons of stuff that you have to try to sift through in all of your free time.
Hoping you'll go away.
So in my case, when I requested a validation, so when I got this notice from this company, I requested a validation and I gave them very specific things. I said, I want you guys to provide under the penalty of perjury that you own this contract, that I have a contract with you, that there's nothing wrong with this purported amount you're claiming I owe. I went through the whole 9 yards. I got a response back from them, and all it was we checked with the original creditor and this is valid. That's not what I asked. That's not what I asked for.
Well, it's like I could have done that.
Exactly. So I sent a nicely worded letter back, and I was like, well, I appreciate you guys doing that. However, this isn't what I asked for, and I'm just going to pretend like this never happened. Send me, again, this is my second request, send me verification that you own this debt and that I have an obligation to pay this debt to you, signed under the penalty of perjury. And I've gotten nothing back, and it's been 4 or 5 months now. Okay. So what's the purpose of doing that, you guys? Why would we do that kind of stuff?
To prove they own the debt. I mean,
okay.
It's white collar or fancy crime wrapped up in paperwork and, extreme vocabulary that's meant to confuse people. And if you don't say just simply, show me that you have proof. I can send anybody a letter written with, scholarly vocabulary and signed by, some law firm. If you don't validate that all, why would that person start sending me checks, right? I mean, we know that this type of crime exists, and it behooves the average person to prove that people aren't committing crime.
That's a great response for sure. The main purpose behind this is twofold. Congress, so many people were complaining to the United States Congress about the actions and the unethical actions of these debt collection firms. That they enacted the Fair Debt Collection Practices Act that states you have a right to seek validation. They must provide said validation. There are administrative remedies that they must go through before they can sue you. So you noticed in that complaint that Adrian has is that it stated that Synchrony Bank sent her a statement and she didn't dispute it, so it's got to be valid. that is that administrative remedy that they must follow. However, they missed the big part where it says now you can sue that the entity that can sue is Synchrony Bank, not Portfolio Associates, idiots, whatever they are, and those moron liars. Okay, so the reason why we do this part of it is you get a statement that says you owe me money. Okay, validate it. Again, if I owe it, I owe it. I just want to know, make sure I owe it. Validate it for me. If you can't do that, you need to stop talking to me right now.
Okay, James, let's talk about what is valid validation.
Simple. It's an affidavit. Did I just say that again?
Mm-hmm.
It's an affidavit. Can you guys believe that?
And
an affidavit.
Well, in our case, in our case, what am I asking for?
So you're asking for validation and saying, in your case, right? And this is what you did. You wrote the company who was asking you for money and say, I don't have a contract with you. I don't know who you are. I'm going to need to know who you are before I pay you. Number one. Number two, I'm going to need to know that I have an obligation to pay you. So I need you to send me something that is signed under the penalty of perjury that states, number one, you own my loan. Number two, you have a right to collect on that loan. And number three, you can follow through if I don't.
Right.
Why should that be why is that hard for anyone to sign under the penalty of perjury? That's all it is. It's just an affidavit. They can send a document back that says affidavit of truthfulness of documentation.
Well, because they
You
don't want to go to jail.
review the documentations. We have this, we have the original note. We have the original trust deed. If it's a mortgage, we have the right to collect on this loan, and we have a right to foreclose on this loan. Signed by such and such CEO of company, in witnesses thereof by such and such notary.
So the contract is the big thing. So in case of a mortgage or a bank, you usually sign something somewhere. So if they can't get you the original document, they give you an affidavit that they saw it with their own eyes, and they saw
have it
ink.
for a judge's inspection. Correct.
They saw the original, and I keep saying that if they're going to tell you a photocopy of something from 17 years ago is valid, well, so is my photocopy of my passport at the airport. They should let me on the plane.
Yeah.
They have to validate they have
can't.
the original contract.
That's not proof. In order to bring the claim that you have standing to sue for a unpaid debt, you must have physical possession of the original contract. So
Yep.
Adrian, Portfolio and Associates, now that you're in this lawsuit, you can actually file for discovery.
Okay.
So you can go back and say, please provide me the original copy of the contract, not the original copy, but the original contract. Please provide a verified, certified copy of the original contract that states that I owe you guys money. And we can go through this stuff if you want. Then you can file your motion to dismiss if you want. But either way, these guys are barking up the wrong tree, and they're just hoping that you're going to settle. That's all it is.
We should do a show on the response and how to do it.
Yeah.
Step by
I think
step.
you know what? If you guys are okay with it, maybe we can do that next week. Would you be all right coming back, Adrian?
Again, I'll put on different sweatshirt, but yeah.
Well, Erica got all dolled up for us today. Come on now.
I know, I can't compete with that. It's just,
I'm just teasing you guys. No, that's great. I would love that. So then that way it's more of a workshop of like, hey, this is how we do this, and this is your next step and what we can do. I'd love to do that.
I think that would be helpful.
For sure.
I would appreciate it. That's for sure.
Yeah, you bet. And that's why I reached out to you and was to see if you'd be willing to come on the show, because we want to help. So,
Awesome.
let's plan on that then. But again, you guys, this is what you have to know. You get anything in the mail from a debt collector, ask for validation of the debt. Ask for proof. I demand strict proof that I owe you money.
Right. In terms of a contract.
If I haven't, let me see real quick. Since we're talking, go ahead, Justice. I'm gonna look for a document. I'm gonna open it up on my screen.
So if you don't have a contract with someone, why do you owe them anything? So if I sell, if I sell James my car, right, and he's paying me because we have a contract on a monthly basis, and he decides to give that car away to someone else, that person doesn't owe me money. I don't have a contract with that person. James still owes me the money. We contracted, we wrote a bill of sale, we have a piece of paper under God's faith, we made a contract with one another. So just because these organizations say they're going to sell you their debt that they charged off, you have to get validation from this other company. Why should you pay them? You're not in contract with them. And they have to prove it. They have to show you the law and the reasons why you have to pay them.
Oh, here it is right here.
It would be nice if people explained that like the debt collection company was the car. Like, that's a good analogy.
Yeah.
Because you just get these threatening letters and you don't know.
Yeah,
that's what I was saying. They factor up all this law with fancy paperwork and fancy vocabulary and scare the hell out of people.
Yeah. Okay. Let me show you. This is what I wrote up, and I will post this in our affidavits group so we can see this. Let me see if I can make this.
Oh, love the AFNI.
Yep. AFNI. AFNI. That's who they were. So here's what I said. Dear sir or madam, you are in receipt of notice under the authority of the Fair Debt Collections Practices Act regarding your file, and this is the account number. It is not now, nor has it ever been my intention to avoid paying any obligation that I lawfully owe. In order that I can make arrangements to pay an obligation which I may owe, please document and verify the debt by complying in good faith with this request for validation and notice that I dispute part or all of the alleged debt. So here's what I'm asking. Number one, please furnish a copy of the original promissory note redacting my social security number to prevent identity theft and state under penalty of perjury that your client, Sprint, is the holder in due course of the promissory note and will produce the original for my own and a judge's inspection should there be a trial to contest the matters. Number two, please produce the account and general ledger statement showing the full accounting of the alleged obligation which you are now attempting to collect. Number three, please identify by name and address all persons, corporations, associations, or any other parties having an interest in legal proceedings regarding the alleged debt. Number four, please verify under penalty of perjury that as a debt collector, you have not purchased evidence of debt and are proceeding with collection activity in the name of the original maker of the note. That's exactly what happened to you, Adrian.
Isn't Sprint out of business, James?
What's that?
Isn't Sprint out of business?
Yeah.
Yeah, I got one of those in the mail the other day too from Sprint, and I just tore it up and threw it away.
Yep.
Number five, anything.
Please verify under penalty of perjury that you know and understand that certain clauses in a contract of adhesion, such as a so-called forum selection clause, are unenforceable unless the party to whom the contract is extended could have rejected the clause without impunity. Every single credit card or every single credit account that's not a mortgage or a car loan is a contract of adhesion. Okay?
Say that again.
Contract of adhesion.
Every single what?
Every single credit card is a contract of adhesion. And
I've read number 5 10 times, and I'm still trying to understand what it's saying exactly.
So what it means is this: it's a continuous offer to contract. So here's the difference. Erica, you come to me and say, I need $100. I lend you $100. That's it. It's one time. It's not where I will give you a quote unquote line of credit for up to $500 and you borrow 100 here, pay it back, borrow another 200, pay it back, borrow another 100 here, pay it back. That is a continuous offer to contract. It's a contract of adhesion. Just like it sounds, it sticks. It's a contract of stickiness.
Okay.
Those types of contracts cannot be assigned. Okay. Let's see. Number 6, please verify under penalty of perjury that you know and understand that cell phone contracts are a series of continuing offers to contract and as such are non-transferable. Because this was Sprint.
I didn't know that.
Yep. Please provide written verification from the stated creditor that you are authorized to act for them. And number 8, please verify that you know and understand that contacting me again after receipt of this notice without providing procedurally proper validation of the debt constitutes the use of interstate communications in a scheme of fraud by advancing a writing that you know is false with the intention that others rely on the written communication to their detriment. What is that? Do you guys know? I'll type it down here for you. Ready? Ready for this?
Mail fraud? No. Oh, RICO. Oh.
What it is. RICO. Okay. And then I put on here with a copy to the Consumer Response Center, the Federal Trade Commission. You know, it's the, not the FCC, but, or maybe it is the FCC. I don't remember. So anyway, that's what I did. And I forgot, I haven't posted this in our group, but I will. Okay. Any questions on that?
You said that's the one you sent and that you haven't heard from them?
Yep, I sent them that one and have gotten nothing back.
Yeah. So it's interesting how that's working because Sprint was absorbed by T-Mobile, right?
Mm-hmm.
And yep. I had the same situation with Sprint, and it was like I paid our last bill. We were done, and then all of a sudden they come after me and go, "Oh, this was for the few months after you paid the bill. Yeah. This was the stuff that wasn't tallied in yet." I'm like, no. Yep. You pay the last bill, you pay the last bill, right? So I just ignored it. And I'm like, nope, we're done. We paid. And then all of a sudden a year goes by, or 2 years even. And like I said, just something came in the mail the other day. And I was like, what are they doing? So how does it work? A company gets absorbed or purchased or whatever it was called. Now they're out of business. What gives them the right to collect?
Well, they don't. That's my point is they charged off all of their open in their books, in their accounting books, if they had anything that was left unpaid that wasn't part of the original agreement to go to the new company, they charge it all off. And then they just go out and go, hey, we can make a little extra money here. So this is what I'm saying is like, you guys want to, well, maybe it's not the best way to do it, but you know, these like Sprint or these other companies are no longer in business. They just sold the charged off debt to somebody, and now they're coming and go, oh, we can go after and collect it for this people. We're going to, but again, it's like Alphonse says, hey, guess what? I'm not your average monkey.
Yeah.
Right. And I think it's important too, and correct me if I'm wrong on this, but this is a waste of my time to have to deal with all these people who keep telling me that I owe them something for me to draft something and write something and do all the blah, blah, blah. I'm going to not do that for free. Like if you're going to send me something, I'm going to also respond in my notice that this is what I'm charging for my time. For everything that I have to send to you. This is the amount of money that I'm charging for that. And then I'm going to send them a bill afterwards. So, and if they don't pay it, then they're in dishonor because I already set the law of what it was going to be from this point forward.
So the only thing I would correct you on that, you're not wrong, Erica. You absolutely have a right to your time. Your time is valuable and everybody has a right to be paid. The only thing I would state differently is instead of sending them a bill, I would just file a lawsuit in small claims court. So whatever you charge them for, right? You know, it depends on every state. Some states you can go up to $20,000 in small claims. Some states are less than that. It depends.
Well, wouldn't I need to provide them opportunity to make remedy?
You're doing that, right? You're sending them a notice.
The whole idea is to always be in honor and say, look, this is the expectation that I'm setting for myself. Yeah. If you move forward, that's being a grown-up, right?
Yeah, it is. It's like, hey, I had to spend time defending myself from this frivolous garbage. There's cost for that. So I'm sending you my notice and fee schedule, if that's what you want to call it, and your opportunity to cure. There is nothing wrong with trying to be civil and administrative about it. Now, you ask some people, like Alphonse or Steve Emerson, they're like, yeah, quit wasting your time with that. Let's just go sue them. Okay, that works for you. This is what I choose to do. Now, everybody's different. What I'm telling you is I don't want you to get, and I'm not saying you specifically, Erica, I'm just saying you in a general sense of the term of the word. I don't want people to get confused that you can just start sending bills to people because you can and will. You could be brought up on RICO charges, which is what you don't want to do. So this is why I'm saying is there's nothing wrong with saying, hey, I'm giving you guys an opportunity. This is your final opportunity and notice to cure.
Now,
Right.
what would constitute a RICO charge, James, on
What's
her
that?
behalf? What would constitute RICO on her behalf? Just
So,
charging
like,
for her time.
Yeah, just like what I said there. Creating documentation that which you know to be false. Now, I'm not saying it is false.
Well, that's what I'm saying. Why does that
paper terrorism, I think, is another
Yeah,
way.
it's more along the line. Mail fraud would be another one. 18
Yeah, if
US
my part-time job was just sitting around writing up notices to everyone telling them that they're doing this to me, I'm going to do this. That is not the case at all. I would only ever reserve that kind of a notice if I'm going to be willing to see it through to the end, because I have proof that this is becoming a burdensome activity in my life. And I've asked you for remedy 3 times now. And now there's no controversy before the court. I just make my claim and I say, this is the bill. He's in debt to me.
Because that's again, this is all very damning evidence, right? Hey, Your Honor, I gave them an opportunity to cure. I did everything administratively to resolve this without bringing my issue before the court, and they chose to ignore me.
I figure so many things can just be resolved if we were just grown-ups and just talk to each other like that. If you can just find the right man or woman who's bringing the issue and be like, hey, all right, here's the deal. Let's just resolve this right here. Instead of going to daddy judge and be like, he did this and she did this. Can you tell him to stop doing that, please?
There's no money in that, Erica.
Right. There's no money in being a grown-up and just being like, hey, this is a situation. Can you stop doing the things?
That's what it all boils down to.
Guys, this is the problem that our nation is facing. Is there are very few grown-ups left in the room. I mean, anywhere. Go back to the story we told earlier about that young man with that police shooting. Were there any grown-ups involved in that situation? No. No. You had a bunch of people thinking. They weren't thinking.
Yeah.
Is this a sad situation?
Very.
So this is why. Erica, you're not wrong. You're not wrong. Hey, I'm trying to be the grown-up in the room here.
Right.
You brought a frivolous claim against me. I tell you you're wrong, and I'm charging you for my time. I'm giving you an opportunity to cure before I go into court and sue you for 3 times that amount.
Right.
There's nothing wrong with that. As a matter of fact, I know a lot of liars that use that tactic a lot. So, all right. With that, we're going to wrap this episode up. A little more than an hour. Adrian, thanks so much for joining us. Appreciate you being here and for willing to share your situation.
Oh, thank you
for being a use case study for us. So for next week, guys, we're going to talk about, okay, you've been sued. Now what do you do? How do you handle this? So we're going to talk about that. We're going to do more of a workshop type feel. I will do my best to get as much of the stuff done ahead of time. Justice knows I'm up to my neck right now in getting her new lawsuit done. I've got a couple of other things I'm trying to do for some people. So life is crazy and busy, but I will do my best.
Yeah,
I think there's value too in just working through the process of drafting it. So don't feel like you have to have too much of it done.
I don't want to have a lot of it done. I just want to have the basic stuff, like the title and that kind of stuff. And then we can actually just kind of write it out as we go.
Yeah. That's helpful to help think through the process of why you're choosing certain phrases and stuff like that. Good.
Yeah, I don't have a problem having you guys open up the mind of the mad scientist. I don't have a problem with that at all.
Do we want to start what you do after the answers, or do we want to go over how to answer the summons?
Yeah, so what you already filed your answers, correct?
Yeah, I had my 21 days.
Yeah, that's right. So now that you filed your answers, the next step in the process is you guys would go to discovery. So discovery is where, and do you have, Adrian, do you have Dr. Graves' course, the How to Win in Court?
I don't. I am not able to get that until after taxes.
Okay, that's fine. That's totally fine. When you do get that, you're going to learn, the process of how this works. So the next step in the lawsuit is once an answer has been filed, both parties move to discovery, and you guys have every right to ask for things. Hey, where's your evidence? Show your proof. Show your evidence. And so you would file a motion with the court for discovery, and you would ask for certain things. which we can talk about. But at this point, I don't even know if you need to do that. You can. I mean, it's just more damning. And the nice thing too is if you get it on the public record within the court, you can use that in your other lawsuit going after them to show that they didn't have anything and that they purported fraud and they committed fraud upon the court. So it's a good thing to do. And then once you go from the discovery, if you're still a dispute in the parties, then the court will usually schedule a pre-trial scheduled hearing where you guys will get together before there's a trial of some kind. But we're getting ahead of myself. 99.9% of the time, these things never go to trial because, as Dr. Graves says, discovery is where lawsuits go to die. So,
yeah.
Okay. So with that, you guys, I'm going to wish you a blissful, happy weekend. I hope you guys all have a great weekend and a good week coming up. I got lots to talk about. Real quick, opening up our show next week, we got a ruling from the court on a case that was ridiculous. I want to talk about that for a few minutes, and then we'll jump into helping Adrienne on her next step. So,
okay.
Anything else you guys want to say before we part?
I would say if anybody's in this situation, call the company that's trying to get money from you and ask them to provide you with the contract.
There you go.
You won't have to get to Adrienne's point.
Yeah.
And, I mean, it worked like a charm for me. I basically said, I only contracted with American Express. You're trying to extort money from me. Don't ever call me again. And they never did. So I would just ask them to provide that.
And that is a right that you have as according to that Fair Debt Collection Practices Act. If you ask them to stop calling you, they must stop calling you. And say, oh, by the way, the only communication I want from you is going to be through the good old-fashioned postal service between now and then. So,
yeah,
okay.
and we might hopefully do another Q&A on Telegram.
I know.
James can squeeze in the time.
I'm doing what I can. I want to. Erica, anything you want to throw in before we say goodbye?
I just always encourage everyone to assume that everyone is for your good until you realize that they're not, and then destroy them. No, I'm just
and then show no mercy.
But no, I'm serious. When I have so much good luck in my life just because I'm always being so transparent with every single person that I deal with, every single man and woman that I deal with. And if I even just say, look, I'm really confused by what you're saying. I don't really fully understand what you're saying, or I'm really feeling a little nervous about what we're talking about here. Just being transparent. People are generally good. I really do believe that. Even just going into the courthouses and dealing with everyone, they're so nice. They don't know what they're a part of, and they don't realize the whole big picture of things. Police officers are doing what they're instructed to be doing. Nurses are being instructed to, they're doing what they're being instructed to do. But if you can appeal soul to soul with the man or the woman across from you, just really take advantage of that and not take advantage of it, but use it to explain what it is, that the wrong that is trying to be committed against you and the role that they're playing in to do it. And it really does make a difference to people to do that. It can stop controversy before it even gets to the point of where we're having to go into the ring with Mike Tyson in the, that's what it feels like. Seriously, because we're just
going to bite your ear off. Yeah.
We're normal people, James. We don't have time to write up these beautiful documents that you do. You're going up against Mike Tyson, though, someone who's been doing it for 20 years. We have the capability, something that every single man and woman can do is to just listen to your gut. When you know that you're being wronged about something, you don't have to know the statute, code, rule, law, ordinance for it. No. You just have to know in your gut that it's wrong what they're doing, and then be able to communicate it and stand on your right as a person, as a man or a woman, to say, you're trying to come against me in a wrong. Is that your intent? That right there can stop the controversy.
Yeah.
And just be good grown-ups, everybody. Just do it. Don't be afraid.
Is it your intention to try to defraud me?
Right. Is it your intent to extort me? Because that's what it looks like by what you're doing.
Yeah.
You can't provide that to me. It's going to look like a trespass against me in the way of fraud or extortion.
Yeah.
And I really don't want to have to do that.
Yeah, you use those terms. I mean, because again, to your point, Erica, and Adrian probably felt the same way. When you called in, it's like, I guarantee whoever that answered the phone, they don't know that they're extorting money.
Right.
Is it your intent to attempt to extort from me? Is that what you're trying to do here? Oh, no. I mean, you just have a bill. You got to pay us. I hear what you're saying. And I see you understand, or you think that I have a bill that's owed, but I can't pay anything unless I know that it's legit.
And if you're always acting in honor, always tell the truth, even to yourself, and always act in honor and make a vow to do no harm to anyone. What crime will you ever be committing then?
Exactly. How easy is it to remember a lie that you told someone 2 or 3 years down the road?
Right.
How easy is it to remember the truth that you told someone 2, 3 years ago?
I'm a terrible liar in general, so.
Good. That's a gift.
This is what I teach my kids. It's like, you guys, it's a lot easier to remember the truth. Trust me.
A lot of energy to keep that up.
Yeah.
It's a big system that's been created from the people who are trying to commit fraud to the average worker. And everybody's done it. Can I speak to your supervisor because you're not getting remedy, right, on a call?
Yep.
Well, by the time you get to the third person, they know what's going on.
Yep.
Well, that's how it works all the way to the top. So Erica's point is just so true.
Yep.
Always just be kind and loving, and
just be kind and loving, and assume that no one's trying to harm you unless you realize that they really are.
They really are.
And then call it out, and then stand on your rights.
Yep. Which doesn't always work. That's what the courts are for.
I agree. Good stuff, you guys. Okay, everybody. Thank you so much for tuning in.
Nice to meet you.
Thank you.
Yes,
too.
Adrian, thank you so much for being here. We'll see you again next Friday.
All right.
Everyone else, thank you for listening, watching, however you're tuning into us. We really do appreciate you. We love you. Just help us get this information out to as many people as you can. And with that, God bless you all. Have a great weekend, and until next week.
God bless. Thank you.